A very good morning, ladies and gentlemen. Welcome to Legal Era's 7th Annual Insolvency and Bankruptcy Summit 2022. Amongst us today are the decision makers from the world of law and business, eminent experts, elite business lawyers, global thought leaders. We also have professionals from across geographies and domains. And with this power packed virtual gathering, we are ready to address and share our perspectives and know how on India's path breaking economic legislation, the IBC. Legal Era, as you all know, has been associated with the insolvency law from the court's inception, as well the 6 insolvency summits have been hosted so far. Legal Era has been preparing statements and reports on the IBC and deliberating on them annually. Legal Era is a mega global think tank of expert leaders, professionals in business and law, renowned for transforming the narratives, influencing decision-making process, enabling strategic vision, driving pragmatic changes that impact the legal professions and the industry. Legal Era, Legal Media Group is in the business of empowering the legal community and the industry since 2007. So taking things forward, today's Insolvency and Bankruptcy Summit is indeed the conference and the panels are indeed going to be very interesting and insightful. The high-level conversations for today are on the range of new legal trends, developments in insolvency, mediation under the code, IBC, and financial service providers, cross-border insolvency framework, the role of COC as a key stakeholder, group insolvency, mapping the trends, analyzing the opportunities, the challenges, and more. So stay with us all along to learn, unlearn, relearn, share, collaborate, and grow. Without a doubt, the IBC, as we all know, it holds the key to Indian economy, industry, and growth. Amongst all IBC legislations, IBC is distinct. It's not just that it connects law with economics. To point an important observation here, as Honorable Justice Sikri pointed out at the 6th summit last year, that IBC also connects an important chord with our country's economic progress, more so in the current digitalized, interdependent, and intricately connected world. As we take the deliberations forward, I leave you here with a very powerful thought by Oliver Holmes, American jurist, legal scholar, and former associate justice of the Supreme Court of the United States of America. And the quote says, I quote, man's mind, once stretched by a new idea, never regains its original dimensions. So on that note, let's take the deliberations forward for the Bankruptcy and Insolvency Summit for the vision for the court. We're indeed honored to have amongst us the presence of Dr. T.K. Viswanathan, Chairman, Bankruptcy Law Reforms Committee. Dr. Viswanathan, as we all know, is a legal luminary who has been awarded with the Distinguished Padma Shri by the President of India. He has held various positions in academia, Government of India, Lok Sabha, amongst others. During the remarkable 4 decades of his career, he has served as a lawyer, a professor of jurisprudence, Secretary to the Government of India in the Ministry of Law and Justice, Secretary General of the Lok Sabha. He has drafted many landmark legislations over the past 2 decades, and the government has indeed immensely benefited from his expertise in legislative drafting and in parliamentary and constitutional matters too. So, on that note, warm greetings. Namaskar to Dr. T.K. Viswanathan, Chairman, Bankruptcy Law Reforms Committee, and we invite Sir to present the vision for the code for the opening address. Dr. T.K. Viswanathan, please.
Thank you. Thank you, Dr. Amna. Good morning, Shardul. Shardul, good morning. Aarti and all the viewers. I am speaking from a different time zone. So I just, it's out. I mean, really, it's really 12:30 in the night here. And I'm very happy to share my views on this, my pet subject, which is insolvency and bankruptcy. And I've been, ever since I have drafted this legislation, I had frequent occasions to defend my code in various forums. And I'm very grateful to Akriti and the legal era to giving this opportunity to defend my code in various forums. Let me start with saying how we started and how we are progressing and how what is the vision for the future of the code. The Insolvency and Bankruptcy Code is a jewel in the Indian statute book. It is a historic law reform which is undertaken by the Government of India. Let me justify the statement why I call this as a jewel in the Indian statute book and why it is a historic law reform, unlike the other legislations which the governments have attempted. Till the enactment of the Insolvency and Bankruptcy Code, there is no systematic and continuous law reform based on empirical and social legal research reflecting the living law of the people. Law and action studies was missing. The IBC is changing this trend by introducing a new wave of law reforms which uses big data, data analytics, artificial intelligence, and other market indicators extensively to keep the law in tune with the current economic and social realities. Now, I would like to recollect from what great celebrated jurist Wolfgang Friedman talked about the relationship between law and social change. He, in his book on law and social change, he said, the controversy between those who believe law should essentially follow and not lead, and it should do so clearly formulated social sentiment, and those who believe that law should be a determined agent in the creation of new social norms is one of the recurring themes in the history of legal thoughts. No, the IBC resurrects this age-old controversy with a sharper focus on the relationship between law and economics. The code is a piece of proactive economic legislation and is a result of the government's response to the challenges faced by our country in a fast-paced global economy. The code represents the current market realities in the financial sector and is supplemented by a very rich ecosystem which enables the policymakers and legal researchers to monitor the effectiveness of its implementation, which other acts of parliament hitherto lack. As the provisions of the code have evolved and has been subject to many judicial interpretations, a rich body of bankruptcy jurisprudence has resulted, which speaks volumes for the vitality of the code. Now, there has been criticism against the function of the code in various fora, especially in the media, where the doubts have been cast about whether the law has failed to achieve its object, whether it's a failure. And more recently, the recent report of the Standing Committee on Finance in 2020-21 on the implementation of Insolvency and Bankruptcy Code, Pitfalls and Solutions, 32nd report, submitted to Parliament in August 2021, has made certain recommendations which gives the impression that the code is not achieving its stated objects. The report states that the view that the actual operationalization of the amendments made so far may have altered or even digressed from the basic design of the statute and has given a different orientation to the code and not originally envisioned. The committee also felt that the design and the implementation of the code as it has evolved needs to be revisited, particularly in the light of its original aims and objects, and therefore needs a thorough evaluation of the extent of fulfillment of these aims and objects in the course of implementation of the code over the years. No, before I try to answer all these questions and defend the code, let us try to deal with the shortcomings pointed out by the committee. What are the opportunities and challenges presented by the code, which, if fully capitalized, will facilitate emergence of India as a major restructuring hub of Asia? A brief overview of the innovations in technology and its implementation for the bankruptcy code and law reform in general will enable us to understand the new trend set in by motion by the government by enactment of the code and the series of measures followed up by the government for its effective implementation. The IBC recognizes the asymmetry of information is a critical barrier to fair negotiations or ensuring swiftness of resolution process and provides for a regulated information utility that will make available all relevant credit information to all stakeholders in resolving insolvency and bankruptcy. This role is performed by information utilities, which are the repository of all credit history of debtors. So to make the task easier, the government has taken a slew of measures for datafication of information. Datafication of information refers to transforming words into data, which unleashes numerous uses and possibilities. It is not merely digitization of information from the analog to digital medium. It is much more. To datify a phenomenon and to put it in a quantified format, it can be tabulated and analyzed and made actionable. In order to capture quantifiable information to datify, we need to know how to measure and how to record what we measure. This requires a set of tools. It necessitates a desire to quantify on record. The code is futuristic in design. And can accommodate fast changing technological developments, which has a lightning impact on the financial markets. So, taking this datafication process forward, the central government has taken a slew of measures like amending the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interests Act, which is called the SARFAESI. And this was done in 2016. The title is Enforcement of Security Interests and Recovery of Debt Laws and Miscellaneous Provisions Amendment Act of 2016. This is a landmark legislation in datafication. What are the provisions of the code? The amended act, SARFAESI Act, provides for establishing a central registry which will maintain records of transactions related to secured assets and a central database to integrate records of property registered under various registration systems with the central registry. This is sought to be expanded by providing the legislation in the SARFAESI Act a provision requiring all security interests to be registered with the central registry. Now, this includes integration of registrations made under the Companies Act, Registration Act, Motor Vehicle Act, and secured creditors will not be able to take possession of the collateral unless it is registered with the central agency. Further, these creditors after registration of security assets will have priority over other repayment of debts. Now, this is inserted in the chapter 4A, where it says, Section 26B, the central government can provide for the establishment of central registry. Then it follows it up, central registry. Then the central registry will provide the registration of the central registry will provide a deemed public notice, 26C. 26C says, whenever any registration is done of any transaction, that should be deemed to constitute a public notice. So, and from the date and time of filing of the particulars of such transactions, this is a far-reaching legal reform which is undertaken by the government, but I'm not sure whether it has been implemented right now. Now, the security interests are mandatorily required to be registered, otherwise it cannot be enforced. When the security is registered, it takes priority over other views, including the government views. This is another landmark law reform attempted by the government. And ultimately, there is always a need to create another public credit records authority which can capture ancillary credit information available outside the banking system from designated service providers and making it available in a central database for facilitating efficient credit decision making by credit institutions. So the proposed authority, government is also thinking of having access or data feed from various sources like tax defaulters, overdue status data from tax authorities such as income tax, GSTN, EPFO, municipal corporation, etc., from GSTN platform in respect of customers turnover, tax filing status, which are critical data inputs. Then enforcement actions under SARFACI or IBC or NCLT, all court orders, regulatory action issued by SEBI, RBI, IRDA, by respective regulators, etc., from various other regulatory websites and databases to have a consolidated view of customers on tax compliance, credit defaults, etc. Now, this will give rise to what is we call today as a big data. This big data would serve as an early alert warning system to financial entities in the process of their loan appraisal, loan monitoring. Availability of such database will facilitate efficient and credit decision making by credit institutions. And this is further augmented by the interlinking of websites of the NCLTs and NCLT to other government websites, enabling researchers and policy framers to get a first-hand information about the credit markets on a real-time basis. Not only the impact of the provision of the Insolvency and Bankruptcy Code can be measured and calibrated by the government and parliament, the impact of decisions of NCLT and NCLAT are also available to take remedial actions as may be considered necessary by the government. So the big data about the players in the credit market is readily available for the purposes of Insolvency and Bankruptcy Code. Big data all invites lawyers and judges to make a fundamental change in their approach to the law itself by looking into statistical patterns, predictions, and correlations, in addition to legal rules that purportedly control outcomes, case law, statutory law, procedural rules, and administrative regulations. New techniques of melding traditional statistics and computer science makes it increasingly feasible to analyze large sets of data. These techniques and algorithms developed by statisticians and computer scientists search for patterns in data has a potential to provide a wealth of useful information if we can develop ways to extract it. So IBC places great faith in the wisdom of financial creditors and market forces to decide the outcome of the proceedings under the code. For this purpose, big data about the credit market is readily available for the purpose of the Insolvency and Bankruptcy Code. The ecosystem accompanying the Insolvency and Bankruptcy Code and the implementation of the provisions making use of modern technology and information tools serve as an example how legal reform will shape the future legislations. What are the reasons why the code has been criticized as being a failure, why it has not, whether it has failed to achieve its object? The reasons for the criticism of the code are threefold. First, the Insolvency and Bankruptcy Code represents a transition from a old legal order to a new legal order. And the tension between legal order and the old legal order is always high. And at the moment of such a transition, we are in the middle of such a transition. That is one reason. We are changing, for example, we have changed from a debtor in position to creditor in position. We have changed the test from net worth erosion test to inability to pay. So we find this sort of thing is bound to create some new contention. Secondly, most of the cases that are clogging the tribunals for which code is being unfairly criticized as not being effective are legacy cases which arose before the enactment of the Insolvency and Bankruptcy Code and were caused by the ills plaguing the credit market prior to its enactment. since the code address these concerns, once the backlog is clear, then the credit market will be restored to its normal shape. Secondly, since the big data about the functioning of the code is readily available, it is possible to measure and evaluate the effectiveness of this code and its level and to level criticism. It may not be an exaggeration to state that no other law is as transparent as the insolvency and bankruptcy code, under which effectiveness is readily measurable, subject to evaluation by all stakeholders due to the availability of big data. Thirdly, the code is not a recovery legislation. So judging the code on the benchmark of no number of cases which have gone to liquidation or which have to suffer a large haircut is misplaced. As the code continues its voyage, the ecosystem servicing the code will also gain considerable experience and expertise, which will address many of the shortcomings plaguing the code during the transition from a pre-legal IBC order to a post-legal IBC order. I think the code has come up very well. It has, within a short period of 5 to 6 years, it has delivered. But when the transition is over, I am very sure this will be one of the most important legislations which the government has undertaken. And it is also setting the trend for how future law reform will be attempted. Because no other law has such a mechanism to measure the impact. Legislations are enacted by Parliament are never measured like this. They're all left to the government to take as and when some crisis occurs. But this law is continuously monitored by a standing committee, and all the stakeholders are fully involved, and the response of the government has been very swift. So I really have great faith in this law, and I really congratulate all the stakeholders who contributed to the success of the code. Thank you.
Thank you very much, sir, for those very interesting insights for the need for the law to respond to changing situations and conditions. Thank you so much, Dr. T.K. Viswanathan. Indeed, the vision for the code has been brilliantly summed up by you. Thank you once again, Dr. T.K. Viswanathan.